Can a child custody order be modified after divorce or after the initial custody order was put in place? Because some of custody orders don't come out of divorce. The answer is yeah, absolutely. It is not considered that when a divorce or a custody order goes in place when a child is 2 years old, that should be the order that governs the child until they're 19. Sometimes it is. And what I often advise parents, and quite honestly, our goal is that when we come to a parenting agreement or the court orders one, that they put that in a drawer and never ever look at it again. That is sort of like the gold standard, right? That they just agree going forward and then only pull it out of the drawer when there is no agreement. But in some circumstances where the court has made an order or there's been an agreement, the child's needs change, the parents' needs change, parents move, parents' schedules change, whatever it might be. It might be time to adjust the parenting time schedule. When that time comes, parents can work together, can mediate, or can ask the court to revisit the parenting schedule. There's two ways in which that can be done. One is pretty much after 2 years have passed since the last order, you can simply ask the court to revisit the parenting time. Honestly, if you're doing that, you better have a good reason because you gotta move the court off of inertia, right? You gotta show the court why it's in the best interest of the child to change the parenting time. So I'd say that's probably, that this isn't an articulated standard, but I would call it better have a good reason standard. The second one is a material change of circumstances. If it's been less than 2 years, but something pretty major has changed. A parent has moved a significant distance, a parent's schedule has changed in such a way, or the parent's exercise of their parenting time is not what the court ordered, then there may be a interim need for that person or the other person to go to the court and ask for a modification right away. But yes, the court always has it until the child reaches the age of majority in their power to modify the parenting time in the best interest of the child. When looking to modify a parenting time arrangement or a decision-making or parental responsibility agreement or order of the court, the grounds for doing that can be one of two. One is the simple one, that time has passed. And there's sort of like a little underlying grounds in there, which is that something's changed, right? That you have a good reason for wanting a change because something's changed. The child's changed, child's needs have changed, the parents' needs have changed, parents' schedules have changed in some way. That are sort of the underlying grounds. But really, after 2 years, the only grounds you need are that 2 years have passed. Under 2 years, and you need a substantial change in the circumstances of one or more or both of the parents, or a substantial change with the child. A long distance move, a change in the parents' schedules, a substantial change in the parents' schedule, or a substantial change in the child's needs can all drive a change in parenting time or parental responsibilities even before the 2 years are up. So in Colorado, when there is a parenting plan already in place, or even in the context of a divorce, if one parent moves away, that parent can apply for the child to move with them or not. The court has a variety of factors to consider in whether to approve the child moving with the moving parent or stay with the parent who's staying put. Under the Constitution of the United States of America, no state court, no judge can order a parent not to move. That is a fundamental right. Anybody can move anywhere within the United States that they want to. However, the court does have jurisdiction over the child and can make a decision as to whether the child can be caused to move with the parent over the objection of the other parent. Now, if both parents agree, the court's out of the picture. But if one parent does not agree, then the court will step in and make this decision, once again, based on the best interest of the child. When it regards relocations, once there's been a custody order, so we look at these cases very differently when it's the first determination during a divorce or some other time versus once there has been a custody order. If it's the first determination, it's simply the best interest of the child test. Where is it best for the child to go? Afterwards, it's considered a relocation. So once there's been a custody order and one parent wants to move, again, court can't stop that parent from moving, but to order that the child should move with the parent, the court has a multi-factor test. And I'm not going to go into each and every one of the factors. That would take up an hour. But suffice it to say that this court has a multi-step test and must make findings of fact as to each and every factor in that test before making a determination as to whether or not it is in the best interest of the child to move with the parent that's moving and or stay with the parent that's not moving. In either case, of course, 50-50 usually won't work anymore. And then once the court's made that determination, then either parties can agree or the court can then order a parenting time schedule that more closely matches the needs of the more distant parental relationship.